Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under constitutional law, and we are going to look at the premise of the constitution. Hope I'm loud and clear. Microphone is, yeah, basically. We are under the premise of the constitution, and our major emphasis, or what we are going to look at, we are going to look at the premise of the constitution. The constitution being supreme. Realize that actually before or mediocrely, we have been looking at it indirectly through the history that we are doing, the constitutional history. We highlight it in the times of the colonial period, the repugnance clause of under section 20 of the 1902 order in council. Repugnance clause, that any law that is inconsistent, is any custom or tradition that is inconsistent is null and what? And void. Basically, that is the colonial era. That is historically. But in the present Uganda, realize that the premise of constitution is being highlighted mostly in the Article 2 of the 1995 Constitution. Before even, there's a case of Andrew Lutakome versus Edward Rogumayo. Basically, what you have to bear in mind is that in this case portrayed that the 1967 Constitution was the supreme law. There was a contention that maybe the NCC, the National Consultative Council, maybe its constitution was the one to be used in governing the country. Maybe its minutes that were highlighted in the general meeting were supposed to be binding. But ever court polished up the air and said that the 1967 Constitution was binding. That case happened after the overthrow of Idi Amin Dada, historically. So I'm bringing that element where court highlighted that the Constitution is the supreme law. Basically, in our Uganda, it is the 1995, but all countries, the Constitution is taken as the supreme law. Let it be Kenya, let it be Tanzania, Sudan, even South Africa, where I was last week, basically. Still, they praise the Constitution is the supreme law in a democratic country. So basically, in this essence, what you have to portray or what you have to highlight is that the Constitution, everything that any business that is done in a country, the Constitution must be taken, that they must consider that anything that you are doing, it must be not contradicting with the Constitution. That gives us the mentality that it is the supreme law. That is article, when you read Article 2, that really instates it, fixes it, binds it, that is the supreme law. Article 2, Clause 1, portrays that the Constitution is regarded as the supreme law of the land. And when I try to follow the prints or to mimic the words of Justice Kanyehamba, he said that in the case of Tinyefunza, Major General David Tinyefunza versus Anthony General, he said that the Constitution of Uganda is the supreme law of the land. You get no any other law must be above it. He was very clear. That is the supreme law of the land. In this essence, it provides that the Constitution is the supreme law. Any other business, the Constitution must be regarded as the supreme law. Something that is supreme is something that is not questionable. But ever the one that it questions your actions, the lower actions you get. So anything that you do, it must not be inconsistent with the Constitution. So when you go to the premise of the Constitution, realize that your point as you are discussing, you are supposed to say that the premise of the Constitution is highlighted as the supreme law, and it must be considered as supreme law of the what? Of the land. Secondly, as you are going to clause 2, remember it provides that any other law or custom that is inconsistent with the provisions of the Constitution is null and what? And void. This portrays that the Constitution being supreme portrays that the premise of the Constitution makes any other law to be null and void once it is inconsistent. Basically, I will give the case of Uganda Women Association of Millionaires versus Anthony General, where sections of the Divorce Acts were repealed. Reason being that they were inconsistent with Article 21 that was talking about the right to equality. That is, then you also have also the case of Andrew Mwenda versus, and Charles Onyango Obo versus Anthony General, to also provide that the offense of sedition that was under 39 and 40, it was inconsistent with the Article 29 freedom of expression, among others. So this portrays that any other law that is there, that is in existing, but it is null and void, but it is inconsistent, the provision is null and void. So it doesn't bind, you get. So basically note that in mind. We also see the case of where they say that basically there is also the element that we see the element that we see in clause 2, where still under clause 2, they say that any custom that is inconsistent is also null and void, which means all customs that are must be practiced by a certain society or village must be in conformity with the provisions of the constitution. This gives us in mind, what does it portray in mind? That if at all the custom is there in existence, must be in line with the provisions. We see the case of Salvatore Abucci versus Anthony Geno. The Witchcraft Act was repealed, reason being that it was contradicting with a lot of provisions in the Constitution. It brought someone was deprived of right to property, Article 26, to reside in any part of the country, Article 37 or 39 there. So basically, it was a kind of unfair. You get, so that such custom that was practiced by people, it was removed. You get, so the custom must be in conformity. Even the quotation came in Bruno Chiuwa versus Juliet Namazi and Ivan Selunkuma. The quotation of people getting married from the same clan. You get, the Ndiga. So in this essence, since it is, when you read actually section 15 of the Judicature Act provides that the courts must apply customary. That's where they say that at least this no must be considered. But nevertheless, your custom must not be inconsistent. Reason being that in Bruno Chiuwa, they considered that custom because it was not contradicting with any provisions of the Constitution. So that custom that was allowed, that a person is not allowed to marry a person of the same clan. Let it be Ndiga and Chima among others. You get. So in that essence gives that element. You get. Realize that there is Zachariah Olum and others versus Anthony Geno, whereby even in that case, personal liberty was violated basically. That is that from Article 22, 23, 41, and 44. Read them tentatively. All those articles were violated in the case of Zachariah Olum. Then also the supremacy of the Constitution. Nevertheless, the supremacy of the Constitution is not only in Article 2, but however, when you go to Article 20 of the 1995 Constitution, also provides that all agencies, government bodies, organizations must protect, promote, you get, the rights of people that are provided in Chapter 4 of the Constitution. That is like an order that the Constitution provides to anybody, any agency, any organization in the country. So that gives the element of, that is the supremacy, because there is that issue, that order. You get, that all agency must, the case of Opoloti versus Anthony Geno, it was that the president, the executive body, had went overboard. You get, actually, it had went overboard, whereby realized that it had passed astray on the rights of that army person who was Opoloti. The case of Karuhanga versus Anthony Geno, still the president had gone overboard by appointing Odochi, yet the Constitution provides that someone must retire as the Chief Justice when he's at the age of 70. You get. So basically, this implies that the Constitution is the supreme law. You get. Then also, still the supremacy of the Constitution or the same constitution gives powers to the bodies to make laws. If it is not the constitution, anybody cannot make law. The authority comes from the constitution. If it is not the constitution, then it is non-existent. Anybody that makes laws that is when it is not by the authority of the constitution, those laws are null and what? And void. Related to Article 79, it provides powers to the parliament to make laws of the country for the easy governance. You get 79(1) parliament. So this implies that it is only parliament, it is the constitution. But when it goes to clause 2, it also provides the same parliament to delegate. If it wasn't the constitution, there couldn't be delegation. But we are looking at the supremacy where the parliament is, where the constitution is acting as the supreme law. You get. So basically, that's the few that I can highlight about the supremacy. But also you have to highlight that all other bodies gain their power from the supremacy of the constitution. All other bodies, let it be the president, let it be the judiciary, let it be the legislature, all of them they deprive. You get. Relate to that, you can say that chapter 6 provides for the legislature. The powers are invested there. Beyond those powers is acting ultra vires. Beyond those powers is abuse of discretionary powers. Chapter 7 provides for the executive. The powers of the executive, they are there. Beyond those powers, it is acting ultra vires. Beyond those powers is abuse of discretionary powers. Chapter 8 provides for the judiciary. Beyond those powers is abuse of office, abuse of discretionary powers, which means actually the constitution brings a regulation in the organs of government. You get. So other than that, thank you for listening and thank you for watching. So basically that is the topic of supremacy of the constitution. Thank you for listening and stay blessed.